welcome everyone. I'll invite Parul to give a welcome note.
Yeah, thanks.
Nishith Desai Associates.
Thanks, Khushbu. Thanks everyone for making time to come here for this event that we have exclusively for Gift City. So we have IQEQ joining us, and we will also have someone from IFSCA who's going to be joining us online. But just really to set the context of what we're talking about here and how far Gift City has really come here. Interestingly, this idea of Gift City was given by none other than Mr. Nishith Desai himself. And this is when, Mr. Modi was the CM of Gujarat, and this idea was, was put in his mind, I think when you were walking down the Sabarmati River or something like that, right? And so it took a few years for that to get fructified. And the cornerstone was kind of laid in 2018, 2008, and then finally the official inauguration happened in 2015. Since then, now 2024, Gift City is widely popular now. It's really ranked up the global financial index. It's actually taken over Mumbai, and it's what it's meant to be. It's a financial center. IFSCA has been doing its bit to make sure that, from a reputation perspective, from a standpoint of regulations, we are considered to be at par with, with overseas regulations and overseas, reputation. And that can really be seen because, when we see the kind of activities that are happening in IFSCA right now, whether it's in the capital markets, it's in the banking, it's fund industry, aircraft leasing, insurance, there is quite a bit of activity which is happening. In fact, the capital markets, themselves, for the listing on the IFSCA are showing a turnover of almost, $100 billion. We're seeing, almost 168 schemes have already been set up. IFSCA has come a long way in changing regulations, making it more palatable for people to set up funds in Gift City. Of course, there are certain nuances with respect to raising capital in India and then investing in Gift City. But on the whole, when you compare to foreign jurisdictions like, Singapore or ADGM, even Mauritius, we see a very high level of interest in setting up Gift City. One of the reasons is also because the cost of setting up in Gift City and the ease of doing business in Gift City, also the manner in which the regulators, are open to hearing, problems around Gift City and finding solutions to such problems. On the whole, it's coming up quite well. On the slight bit of a flip side, we do see, little bit of investor concerns time and again saying that, is this something which is long term, or is this the government's project right now? Is this really a long-term road? Because obviously other jurisdictions like, let's say Singapore, or even if you look at some jurisdictions in the EU, they have been there for decades now. But there is always a start to it, and I think we are quite bullish on the entire, Gift City regime. We are seeing institutional investors, even sovereign funds investing directly in Gift City. So to that extent, investors are not completely, it's more about understanding what the regime is really about. We see new developments happening around the Gift City front very frequently. All these developments are geared towards making Gift City more flexible, at par with foreign jurisdictions where laws and regulations are concerned. We see infrastructure being developed. We are also seeing, now people being available because, we would know that there is a requirement for people to be employed in Gift City, at least for funds there is. But we are seeing that, that crop also coming up in Gift City. So on the whole, it's really shaping up quite well. We've seen a lot of, large players like, we've seen New Zealand Bank, we've seen Berkeley Insurance Company, a lot of insurers are coming. We've seen some really large names that are setting up shop in Gift City. We are also seeing it being developed as a global finance center for people to set up their financial operations. So I think with that, the whole idea of this, this event is, is to really have a two-way conversation. Of course, we'll have a panel discussion here and we'll talk about some of the nuances. We'll talk about our experience as NTA, what some of our clients have faced at the grassroots level, plus some of the good things that have that happened. RT, Sudhir and others are going to put up their point. And, we'll also look at a very engaging conversation from your side, to see what your expectations are. We'll have someone from ISCA joining us. So therefore, feel free to voice your concerns or have any questions that you might have, which, they can be taken back. It's always a two-way communication. And like I said, the regulators are very open to this. And with that, Nishith bhai, maybe if you would want to just
No, I was
say a
thinking,
few
why
words.
not we have introduction of iconic people here around?
Yeah.
So,
Good. Okay. I'm Sridhar Nagarajan. I manage the region for IQ,
Little bit here.
which is Africa, Middle East, and Asia. I'm based out of Singapore. Banker by profession. Many years in Mumbai. Of course, have quite a lot of working experience in Mauritius, and now moved to Singapore. So, really happy to, of course, been a proponent of GIFT. Actually, I've been clear that you have to have a setup, so IQQ is fully set up in GIFT. Absolutely happy to see in the last 4 years how much GIFT has grown. So I'm also as keen as you to listen to the panel, what they're going to say. Thank you.
I'm Aarti Ramakrishnan. Nishith bhai may not know this, but I'm a lawyer by qualification. So I went to National Law School, Bangalore, and many of my friends worked for NDA. I never practiced as a lawyer. Went on to do my MBA at IIM Calcutta immediately after that. And then I was an investment banker for 15 years. So I started my career at Merrill and I spent time at HSBC and Credit Suisse, basically doing M&A capital markets, structured finance, private equity. I then set up and ran the business for Mizuho. I was country head for their investment bank in India for a number of years. And then in 2017, I stepped out to be an entrepreneur. Seeded a small digital lending startup, which sort of went on to scale, get institutional funding, and the management team was sort of working very well with it. That led me to work with seed to Series B companies. So I'm not a wealth or an asset manager actually, but I came across a very interesting company called Crystal.ai. They were a fintech business headquartered in Singapore, regulated by MAS, and looking to offer global investment solutions to clients. And I thought it had a great use case for India and the Middle East. So my co-founders and I, we partnered up and we basically went B2B, where we tied up a bunch of asset managers, wealth managers to say, think of us as your global shop. Long story short, at least in the LRS space, we realized we were 30-35% market share within 18 months. There was no real challenger. And I was thinking about what else to do to expand the business when 361 called me. Of course, they were one of our partners and Karan and I know each other well. To say that, I'm looking to expand global, would you consider coming on board to build it? So that's what I look after at 361, global platforms, which is broad. We have a setup in Singapore and in GIFT. And we look at, what I like to call rupee to dollar to rupee, but we also look at dollar to dollar. That's the quick introduction. Very excited to be here. So thanks to Nishith bhai and to IQEQ. I think it's a very pertinent topic that we're here to cover. So
it seems that 361 days in a year you work. Set very high benchmark. 4 days holiday, I'm sure you take in a year. Looks like the way.
I take a lot more than that.
But let me ask you.
Thank you, sir. I'm Sudhir. I'm from Aditya Birla Sun Life Asset Management Company. I'm acting as a principal officer as well as head of GIFT City business. So we are one of the first of asset management company to set up the office there, and also first company to set up a fund investing in outside India, a global fund for resident investors through GIFT City. So we are running already both sides of funds, both inbound and as outbound, and happy to be here, and thank you for the opportunity, sir.
Thank you very much. Anyone else got introduction? Only thing is that do we have Mr. Aditya Sada on the line?
So I introduced myself earlier, but I mean, in retrospect, looking at my grey hair, you would know that I have set up the first private sector mutual fund here in India, which was Taurus Mutual Fund, which is still there in existence with the entire operations for Taurus. Then I moved to ING Group and set up the entire mutual fund operations and middle office, back office for ING Mutual Fund. At that time, it was just ING and not ING Vaishya. I had joined in both the places where our application to SEBI was about to be submitted. So it started much early in my career that I got an exposure to the mutual fund business. I moved to Dubai, worked with a family office largely on real estate. I had done the setup for the share broking license for that firm, both at DIFC as well as ADGM. ADGM had just come up at that time, trying to catch up with the DIFC, those initial days, of course. And came back to India, worked with a company called SS&C Global, who were also a fund administrator. Worked with all the global hedge funds when I started, more on the operation side and the mid office, back office, regulatory compliance, and so on and so forth. Then this company was acquired by a company called SS&C, which was a predominant player on the private equity fund admin side. That gave me an opportunity to work on global private equity funds. I worked on to all sort of private equity, real assets fund, REITs, Invest. And then in that journey, we realized that AIF is a space, private equity is a space we understand. So why not look into the AIF business in India? So for that, SS&C, I have done the entire private equity setup business for SS&C, and then we did the AIF setup. Some of the clients that I had onboarded then, which are in public domain, are the likes of Kedara Capital, Multiples, Chris Capital, A91 Partners, and so on and so forth. And of course, that landed me an opportunity to work with Sridhar, and I joined IQQ, looking forward to do the similar operation setup for the group here in India. So as we speak, we have presence in 4 locations: Mumbai, GIFT, Hyderabad, as well as Noida, and we're looking to kind of scale our operations here.
No, wonderful. So I think welcome everybody once again. Thank you so much. I don't know how much all of you know about NDA. Usually it is a non-disclosure agreement, but it is Nishith Desai Associates. Basically the way in which we described ourselves is we are an India-centric global law firm, and we are a purpose-based firm. So it's just not economics that matters to us, but other things as well. So, and it's not unidimensional firm, it's 3-dimensional purpose. So first purpose is, of course, to do most innovative, complex transactions on a global basis. So clientele includes mostly from the US, almost 70% of our clients are in the US. Of course, they do global work and things like that. Of course, India is one of the interesting places as well. So most of our work until from 1981 to 90 was in the US. And then India opened up in 1991. And I started talking to people about, funds. And in the US, we were already exposed to that, wide variety of things. But when I talked to people about funds, they all thought I was a cheater, and they thought I'm cheat fund. And people laughing, Hopefully now it has changed completely. Now it's like Alibag, right? At one point of time, we used to say, oh, Alibag se aaya kya? Now they say, Alibag se aaya kya? Right? Yes. So I think now, at that point of time, it was embarrassing to talk about funds, And from those days, it's been wonderful. So, another interesting thing that had happened, India opened up to foreign investment. And we do comparative law studies, so I'll tell you a story about that. But so first purpose is to do complex, innovative deals and things like that. So innovation is the core, research is the core to us, number one. Number two, to foster the next generation of socially conscious lawyers. Okay, that's very important. So we are just not here for economics, but also I think we can contribute to something else, etc., etc. And number three, to shape the future of law. Because what we believe that we have to shape the future. We have to shape the world that we want. We have to shape how the regulatory framework should evolve in future. So what we typically do, we look to next 3, 5, 10, 15, 20 years from now and do trend assessment and forecasting with regards to the new technologies, new political, social, economic development that are likely to happen, based on the premise that future may be uncertain but is not unthinkable. So we do a lot of trends. We have a futurist as well. He's not an astrologer, by the way, but he's futurist. And he's PhD in artificial intelligence. Our other colleagues are in engineering. I think you mentioned about engineer. So we are a zoo. We are medical surgeon and lawyer. We have social scientists and lawyers. So we have a slightly different type of organization. We are lawyers ultimately. But the whole idea is that you have to understand the industry in which you operate. And that's how you work. So these are the three purposes on which we basically go. We spend almost 35 to 40% of our time on research, academics, thought leadership, and try to create new business models, new theories, new jurisprudence, and that is how we have really evolved. And India has been extremely generous to us, so we are very happy. Of course, we work on a global basis. And in 1983, I wrote a book in which I had dreamt of I wrote a chapter, and there I wrote about India setting up an offshore center, 83. So Rajiv Gandhi took a lot of interest, VP Singh took, but then everything got fizzled out in between. Then come 1990 and 91, and India opens up, and then we are doing comparative law studies, in which it turned out that while we were doing US-India comparative study, what happened in the US Internal Revenue Code is section 865. Just to give you a little perspective as to how all ecosystem evolves, my specialty has been international tax and globalization. So Code section 865 is worded in a way which is with regard to capital gains is exactly opposite to the way in which it operates in India. So in India, when foreign person sells the shares of an Indian company, India says the source of capital gains tax is India, because it's Indian company shares that are sold, and we have first right to tax. US believes that share is not a tangible thing, it's intangible. Okay, just like IP. So it's located where the holder of security resides. You get my point? Many of you have this background, but I'm just repeating even if you don't know. So US says that it's an IP kind of thing, it's intangible. Share certificate may be physical, but share is intangible. Intangible resides where the person holding the share resides. So if he's a US person, then the shares are located in the US. And if US shareholder has asset in the US, and if it is sold, who has first right to tax? They say we. Okay. So that is what is code section, it is called sourcing rule. And so they said we have first right to tax. Now, there is a conflict. How do you resolve? You try to look at tax treaty. What does tax treaty say? It's very interesting. They say both countries can tax in accordance with their own laws. And the history to the whole tax treaty is this, that tax treaty with US was negotiated for 23 years before even I started my practice. And but last 5 years I was involved in the negotiation of treaty as well. But when Rajiv Gandhi had to go to the US, he said, anyhow I want to close the treaty. So imperfect treaty, but sign it off. So they could not agree on capital gains, and eventually they signed that, okay, both countries can tax, without realizing now there is a double taxation issue. India used to tax capital gains at the rate of 25% long term, and about 50 to 60% tax on the short term. Now look at, if you pay 25% here, 60 is, percent on the, in the US it was 40 to 50% tax at state level separate, right? So you have already lost 70%. Remaining, I think, tax accountants and lawyers take away. So I think that is a little trickier situation. So when we found this is a major problem, and even when we set up first FPI, what was called then FII, Bombay Fund Limited, we found this issue. And for not-for-profit and tax-exempt investor, it was even a bigger issue. And in the process, we said, what do we do? And then we started looking at other tax treaties. Interestingly, Mauritius stumbled on. And when I looked at the treaty, I found Mauritius companies will not pay tax in India, capital gains tax. And history to that was that at that time India was exporting machinery, goods, like SR had a plant and the Bajaj and everything from India was going. So India negotiated treaty to, in a way that they said, you don't tax our Indian companies, we only will tax. Okay. So therefore provision was made that, okay, Indian companies will not pay tax, but they had to provide reciprocal arrangement. So then it was said that, okay, Mauritius will not tax your company. And never it was imagined that Mauritius will invest a penny in India. Okay. It was like a younger brother, you know. So being bullied by big brother, lighter vein. And so that's how the treaty was in 1984 negotiated. Okay. Now when we looked at the treaty, we said, Mauritius, you know, and I was looking at whether US company can set up company in Mauritius and invest in India, because there is no limitation of treaty benefit article in that. And so the whole thing was that Mauritius was a good, interesting place, but I was wondering, where is Mauritius, Malta, Maldives, all Saltile Islands, you don't know where it is. So I took a flight, went there, and some or the other ended up meeting with finance minister and suggested the Webunar offshore financial center. And my book chapter was there, so I gave him the chapter. And it eventually happened, and almost 49% of the investment came into India. But when Mauritius got the benefit, Singapore was also wanting to set up. Now Singapore came little later. It was not alongside. So in Singapore, what happened in 2002, you know, Minister Thurman, and he was a finance minister and education minister. And I may have said you, because you're in Singapore, you know that is my personal friend. And I had to go and train tax department to explain why fund industries. This is 2002, okay, not too old a time. And because they are treating fund industry as a normal, any other investor kind of thing. And nothing much was happening because Mauritius had more tax benefits than Singapore. Then Singapore negotiated the treaty, renegotiated the treaty to provide that give us the same benefit as Mauritius. And the government of India ultimately agreed and said, okay, we'll give you this benefit, but it will be coterminous with Mauritius. Okay. But the moment Singapore got the benefit, more people started moving to Singapore, because establishment of substance was easier in Singapore. Mauritius was a little difficult, right? And so that's how Singapore began to pick up. In fact, Singapore charged 18% GST on the management fees. And then when I spoke with Ms. Thurman and this, and the tax rate was reduced to almost half, 9 or 10% half. Okay, so that's how Singapore became popular. But Singapore is obviously expensive, and takes time. I'm just telling you the story so you understand the background in which we are coming up, right? And in 2007, Mr. Modi wanted to set up infrastructure fund for Gujarat, and I took him to Singapore because I was close to Mr. Thurman and other people there. So we met with different people, and in the evening we were walking on a boat quay. And he said, how come this Singapore has developed offshore financial center? I said, we can also do it. I said, I've been talking about this for a long time, but, India can do the same thing. There's nothing that stops us. And he said, give me a note. Then again, my book chapter was there on the framework for 83 book, 2007. Okay. So next morning, he said, oh, we must do something. So we come back to India, and Oberoi, we had a big meeting, and I was late. So in the big crowd, I was standing at the end. He saw my gray hair and told audience that, okay, Nishith bhai, you told us we should set up offshore center. So he announced that we'll have offshore financial center in Gandhinagar, because, he is what he is, right? So he quickly took a decision, 2007, so it began to happen, and some 300 acres, I don't remember, I guess a little more, 100 acres were devoted. And but by the time it got notified was about 2013. Okay, 6-7 years to do that. Then when he became Prime Minister, he became a pet baby, and then it's no looking back. And the way in which I think it has moved, even still it was struggling to take off. 2017, 18, one of the things that happened, I had conversation, and he said, why it's not picking up? And I said, 1 lakh crores of rupees real estate is held up in a zone where there are except 2 buildings, nothing happening, But the result was that if somebody had to put up any entity, you have to go to 10 different ministry, okay. And so we said, okay, let us have unified regulatory authority. IFCA came up, all of you know that, and I think they have done a tremendous job. It is not very easy in a democratic setup, okay, with number of billion people, billion opinions, to put together something. So ultimately IFCA came up now. So except tax, everybody else is part of it. Some people say it's good. I don't want to talk about it. But anyway, so that's how this whole IFCA has come up. And IFCA, Mr. Injeti and now Mr. Rajaram, they have done a very good job. In few years' time, financial services, the most sensitive sector in any country's, life, and any bad actor can spoil the whole, broth. So that's how it has happened. And there are a lot of things they have done. And in the meanwhile, now that it's moving up, also other competitors have come in, like in between. DIFC has come, but more importantly, ADGM, which is again very aggressive, very good, no doubt about it, expedited stuff. And so, the whole ecosystem, but at least Gift City, as it is called, has a lot of potential on a global basis. We have, most important thing I see is professionals. The professionals like you have done a great job. Anywhere in the world you go, if somewhere along the line you find Indian, and why not we make India a little better place, right? So I think that is where we need to do some work in terms of attracting talent. I am told that talent is something a little difficult to get into, not because of alcohol, but even otherwise we have to see what can be made more. Now I think a lot of things are being done around that. There's few provisions we can introduce for attracting the NRIs so that the tax residency provisions can be more easily resolved. There are a lot of small micro level things that we need to work around. But you are the best judge, you are on the ground, you know pain points. We would love to have your views around, and whatever we can do, we'll be happy. Because it is not we talk from this part of the table, but I think all of you have gone through grueling exercise at times. Even to start a company, sometimes there is difficulty, sometimes, kicking of the things, and especially for foreign people to get apostillment and all those things. Some of you might have already faced that issue. Okay. So what I would like to also do is to see what are the issues that we can do and what can we innovate. Okay. Because there is huge opportunity for innovation, and the whole concept of Gift City, originally I suggested in Andaman Nicobar, by the way, I forgot to tell you that, and I thought separate island, close to Indonesia, only 80 kilometers away and whatnot.
Not Lakshadweep?
Beg your pardon?
Not Lakshadweep. I thought that's
Lakshadweep came only recently when there was no Laksha on that, Nobody paid attention to. But I think Andaman Nicobar was being talked about. And of course, there were army and other people had, say in their ecosystem or ecological issues and whatever it is, right? So we don't go into general. Also, we toyed with idea of having BKC as a financial center. Again, Bombay first, we were all part of it. But, again, that got into little political or whatever other situation, nothing happened. But this was little easier, and you needed somebody who make a decision. So that's how this whole thing came up. Now it's partly on GIFT City, partly on us, to see how do we develop an ecosystem and make it more. I hope that very soon we move to fungibility. Okay, I think rupee needs to be convertible now on a capital account as well. Just to give you a little background, in my book, if you read that, it looks like a Bible. Now it's an old book, but then I opposed exchange controls in 1983. Okay, and heavily criticized. N.K. Gupta was there, and I was just 23 years. I don't know how old I was, but he said, "You're a naughty boy," so he put me on a RBI committee.
I didn't get that.
Oh, see, I didn't get that. I'm sorry, I don't know. She's hearing. जरा इसको रख दो, ये गड़बड़ कर रही है, Alexa. So anyway, just to give, exchange control is something that we really now to focus on. How do we move to capital account convertibility? So first stage, I used to go to IMF library and Article 4 and Article 8 of IMF mandate India to go towards convertibility in the interest of global trade and commerce. They were supposed to be temporary measures in 1945-46 during the World War II, okay, and they got extended, right? Then, so first was trade account convertibility. So 1991, when India opened up, sometime in 92, we opened up trade account. So import exports, the red book became green book. Some of you, I've got more gray hair, so I remember that, but we are partial. Okay, so it used to be red book was really red, so difficult to import anything was a problem. It became a green book, so trade account convertibility came. In 1999, then current account convertibility came, and we got new FEMA, which was supposed to be a Foreign Exchange Management Act instead of control. The whole concept was to get away from control, but still we are into control era. I think that is something that we really need to look at. And so 1999 that happened, and we are all waiting now 2024. I hope we move towards capital account convertibility. One of the biggest debate we had in 1991-92, Chidambaram was the commerce minister and Manmohan Singh was finance and all that. What happened was that the current account convertibility was being supposed, but trade happened. It did not happen for some time. And the main argument at that point of time was, when you allow FIs to come into India, why not put a lock-in period of 3 years minimum? They must come for long term, these, that, those kind of things. And there was a lot of heated debate at times. And ultimately it was said, no, we don't want to put lock-in period. Because once you lock in, capital will be locked in outside, it will not come. Because people are not confident. And good thing we did, and the best decision that we took in entire economic history was that we did not put control on lock-in period for FIs. At that now we call them FPI. That has happened. So more open you are, more capital will come in. It is a matter of, and at that point of time we are just coming out of foreign exchange bankruptcy. You all know that, right? Today we are sitting on $500-600 billion reserve. We can afford to take some risk. So I think that is second step we really need to move fast forward. And other jurisdictions are coming up like ADGM and others, and they are really attracting a lot of capital for whatever, right? It's a financial capital and whatever it is. But it is important that we quickly move to fungibility. Second thing we need to do is to introduce some innovations in exchange control laws. FEMA is such a law which is more policy driven. One of the unfortunate part is that, drafting is sometimes very, very ambiguous, and there is no right of appeal in FEMA. I think we have to keep that right of appeal. So those are some of the things all of us can, and whenever you get chance, you can discuss that. But it is very important. How can a citizen decide behavior of his except by reading the letter of the law? And that is where and otherwise RBI is one of the best department. of all the departments, it may be bureaucratic, it's one of the most honest department. You don't see so much of corruption there. Okay? So people are nice. I think we just need to see that ecosystem, we improve on that. So that's the history of the whole thing. And today is the chance, and we have, opportunity. And I do not know, Mr. Aditya, Sada has been able to join or not.
I think he's there. He's there.
Yeah. Hello, Aditya bhai. How are you?
Hello, Mr. Desai.
How are you? Thank you for joining us.
My pleasure.
Yeah,
Thank you
good.
for having me.
Yeah, most welcome. I went on a bit too long. Please bear with me. Okay. So we would love to hear a few words from you, and about Gift City, what is happening, and what are things that are likely to come up, and especially with regard to fund industry. We would love to hear your thoughts, anything that we can help you, anything we can do, we will be delighted. We are all here. It's nearly house full, and there are people who are anxious to hear you, so I would stop here. But most welcome, please.
And so I think after listening to the background that you provided about the history and the entire journey of Gift City, people really do not need anyone else to speak about how Gift City came into existence, what is IFSC, what is IFSCA, and how the IFSC came into existence. So I think we can skip that part. What would be interesting for the audience here is to know is the areas where IFSC could be witnessing potential growth in the coming future. And I'm sure that quite a lot of members from the audience would be aware that fund management industry is one of those sunrise industries in IFSC which has witnessed rapid growth in a very short period of time. The fund management regulations of IFSCA came into existence in 2022, and since then we have today more than 130 fund management entities and more than 180 schemes launched by those fund management entities. When I say fund management entity, I would take a minute here and explain what the concept the IFSCA follows in terms of its regulatory architecture for the fund management industry. So, unlike registering a product or the fund, what IFSCA does is register the fund management entity, the legal entity which is going to be the manager of a fund or a pool of capital. So we call that entity a fund management entity or FME. Once registered with IFSCA, an FME is allowed to undertake multiple activities in the realm of fund management, be it launching a venture capital scheme or a restricted scheme. Restricted scheme is basically akin to alternative investment funds in the domestic jurisdiction, or providing portfolio management services, launching real estate investment trusts or infrastructure investment trusts. So it's a really wide bouquet of products and services that a fund management entity can offer in GIFT IFSC just by taking one single registration. So far, large amount of these activities, in fact, all the activities have been exclusively oriented towards non-retail products because primarily because of the tax reasons that we had tax regime clarified only for the non-retail schemes. In the recent budget, the Honorable Finance Minister has now clarified the tax regime for retail schemes and exchange traded funds also. So the next wave of growth, the next catalyst for the fund management industry in IFSC, we expect to be the retail schemes. I'm not very sure how many members in the audience belong to the retail fund management side and what exactly is the breakup there between retail and non-retail, but this is a potential opportunity that we see, and considering that the regulations are unified, there is no need for an entity to require another registration from IFSC to launch a retail scheme. So once it is registered with IFSC as a fund management entity under the retail category, the FME is allowed to offer both retail as well as retail kind of products. So those FMEs which have retail category of registration can very well explore this opportunity, which is going to be really huge in the time coming. Second thing which I would like to highlight to the audience here is a recent development, not really very recent. In fact, this took place in June of 2024, when SEBI allowed the funds in IFSC to accept up to 100% contribution from NRIs and OCIs. So this is the first and the only time when SEBI has created an exception for a jurisdiction to accept more than 50% contribution from NRIs and OCI investors. Therefore, there is a huge incentive now for the fund management entities to set up their bases in IFSC, specifically to tap into the large diaspora opportunity. So we are aware, and it's been said at enough and more forums, that India has a large number of diaspora spread across vast parts of the world, and this diaspora is very wealthy, and they are very keen to invest into the rising Indian opportunity. So there is no need to explain the size of the opportunity and the vast amount of interest that is already available. So I hope that fund management entities in IFSC who are present today or who come in the future take up on this opportunity and connect the Indian capital markets, the GIFT IFSC, with the vast number of NRIs, the OCIs, the Indian diaspora present all across the world. So with that, I think I'll take a pause.
Thank you so much, Aditya, and what I would like to do is to open up the floor, but on our side of the table. Parul, you have anything to say, or you have, or Prakhar, you are here somewhere, and let's see if there are thoughts or anything else would like to say. Okay. So I thought let us get ideas, and then we have some kind of fireside chat, so we both can react and respond to that, and together we want to create a better world in Gift City, right? So that's the objective. Idea is to tell what this is. Idea is to find out what more can we do.
I have a question.
You can be louder also.
Sure. And this is directed to the gentleman from Aditya Birla. Could you explain what's the kind of progress that you've seen? Are you seeing retail participation coming into your schemes? How's it? If you could just explain what is ABSL doing in the Gift City?
Sure. As I mentioned, we are the first one to launch that outbound fund. So we had taken a non-retail license to start with, and we are in the thought process of upgrading into the retail, provided the kind of clarification has come in. So as Aditya also mentioned that we have the opportunity to do both sides of the fund. That means you raise the money in India from the investors of resident Indians as well as corporates, and invest outside India. And again, you can raise the money from NRIs, OCIs, or including foreign nationals also, and foreign entities, and bring it to India and invest in India dedicated fund. So we have launched both sides of funds. So we have a fund which we have launched which invests into emerging market strategies, emerging market equities. So where we accept money from resident Indians under the LRS limits, as well as from the corporates under the OPI route. So, and we invest abroad for them. So second opportunity is also for, we have raised money from foreign entities who wants to invest in India dedicated team. So we have launched an ESG thematic fund, ESG theme fund to start with, specifically for foreign entities. So we are also launching an so we have got the approval. So we are in the market promotional phase to do a fund of fund, a feeder fund for Indian mutual fund schemes for our NRI clients. So basically that provides as a specified fund and a wonderful tax neutral opportunity for the NRIs to participate here without much of tax convenience. So if you have to look at, see, these are various opportunities. We also have done on an experimental basis one fund where you raise the money outside India and you also invest outside India. So IFSCA provides a a wide flexibility of fund management opportunities. So all this space, at least from Birla side, we are doing it only in the listed equity space. So again, I think then the unlisted space, equity or a debt space, fixed income space and all, there is a whole lot of additional opportunities is also going to come. I think going forward, yes, we see that the outbound funds could be a bigger opportunity for Indian fund managers, because there's a lots of the Indian investors, so who wants to who have already enough exposures to India and globally gradually are also looking to diversify beyond India. So that's the one. And second also, that today if you see that lots of families, lots of Indians also is moving to US or any other countries outside to for various requirements like education to business. So they are also like can use this opportunity to create or accumulate dollars outside India and hold it for their future requirements. So along with the investments, so the benefits are very wide. Initially, that the Indian investors used to look at investing through the mutual fund scheme for global opportunities. Now that having that limits been exhausted, so now I think this is the only route which the Indian investors have to take a global exposure. So, and I think that's a wide opportunity, and we look at that going to be a big.
Just a follow-on question for that. There's a TCS issue, right?
Right. Yes.
So, is that a challenge for you to mobilize money?
Don't think so. That's because at least currently we have mobilized about 60 million US dollars in this fund. We don't see that as a thing, because mostly that as a HNIs who have been using this route. The TCS also comes to them as a tax credit, which can be adjusted against those any advance tax. So from that perspective, I think there has been an acceptance from the investors.
And this TCS is automatically debited from their bank. You don't have to kind of pay.
Absolutely. So it is not part of that. It happens at the bank level, and further it would be reflecting for them in their credit. So as a tax credit, so it gets adjusted against any of. Or max if there is no any things, though it gets paid out to them in the coming financial year.
You mentioned that you invest in the international markets. So do you have to take a FPI license for those markets, or you have to use interactive brokers?
No, See, you need to probably take those if you're you have two options. So one is that you can do a feeder fund for any of those, because you have an already established fund managers are there outside India, in the US or in many places. You can go through that route. You can do a feeder fund into that. So that is what with the route which you have taken as of now. So if you are looking at a direct stocks, again that you need to register with one of those brokers and go through. So but otherwise I don't think so there's much of other requirements, licensing requirements.
Anyway, I think we can start the panel discussion then.
Yeah.
Sudhir. Because that seems to be the area of interest. Thanks, Sudhir. So you covered a bit of it. What we would like to hear is Aditya Birla Group and yourself. You have quite a lot of experience in multiple jurisdictions. Can you take us through a little bit of comparative study in terms of GIFT and IFSC, in terms of its regulatory flexibility, operational aspects, fundraising? It's a continuation of what you said, but more in a comparative manner to kickstart the conversation.
Yeah, definitely. I think there is more flexibility available at IFSC. Rather than a flexibility, at least I could rather tell that yes, there is a interest that's from the regulator to sit and understand what is that the fund manager wants to do, and what has been the kind of hurdle if he or she is facing, so that and see that what is the solution which they can provide. So initial those days when the PMS was started, though there's not much of PMS has taken off, but even that there is some regulatory changes which was required for someone to take a PMS license and explore that business. Yes, IFSC heard about that. With respect to the ESG themes, the thematic fund which we wanted to launch, there are certain changes which were required in the kind of regulations which they had made, so they were open for that. So I think at every level IFSC is available. They are ready to listen to you. They are ready to provide you the kind of some insights, something, and if there is some changes which is required, which is not going to be a great inconvenience, yes, that I think they have been doing. So if I have to look at, there is a good amount of funds have actually moved from Mauritius to India. And again, definitely that when you are managing a fund in Mauritius, those jurisdictional regulations are different, and there will be some difference with IFSCA here. So, but still, I think the people could move that seamlessly from there, and we've been seeing they're successfully managing without even a kind of any issues with the investor facing when moving the funds from one jurisdiction to another jurisdiction. So,
wonderful. I think actually to just add to what you said, every jurisdiction has its hinterland opportunity.
yes.
It goes without saying, which very diplomatically answer that.
No,
India is-
even for a Indian fund managers, it's completely different. See, when you're looking at that, the other jurisdictions, the fund manager is sitting somewhere, the fund has been there somewhere, then you're raising the fund somewhere else or you're investing somewhere else. But whereas here, and this is the only probably jurisdiction where the fund manager is also sitting there in the same country, the fund is also set up in the same country, the investment is also happening in the same country. So you have, it can be a well coordinated and well managed, jurisdiction or an investment opportunity. Once someone can look at compared to any other jurisdictions.
In fact, one point I'll add here, that anything you do now, internationally particularly, you need a substance. This was not the case earlier. So if you see, maximum number of funds came out of Cayman Islands or BVI, and to some extent from Delaware, but Delaware is slightly different. And how many people sit in Cayman Island, right? But those are the different days. Now that the focus is on substance, and not only because of law, but because people want to look whiter than white or blacker than black. Both are equally good. But the thing is that now you can establish substance and genuine substance. The availability of professionals is very high in India. If we can do something whereby people can move to GIFT City, it will become easier, In fact, one of the thing I remember in 1991-2 when I went there was near complete absence of professionals, financial professionals in Mauritius. And Prime Minister of Mauritius told me, and he spoke at the stock exchange once, and he said, today about 11 to 13% of the GDP is from financial services. And also the professionalism that has grown, I think they have become very professional in Mauritius as well. So it grew financial services sector. I think we have huge opportunity in GIFT City. And I'm very proud of the fact that this has come into being. We should start doing more and more experiments. And the whole idea is, if only India is there, one thing, but GIFT City is a foreign enclave conceptually. It's a foreign territory, although under our control, but it's a great opportunity for us to create a laboratory out of it. Because India, once again, I would say, is a great place for experimentation, where the cost of failure is low. Correct? Where the cost of failure is low, but upside is very high because the market is big. So, and I think the same model which we develop in India, whether in GIFT City or otherwise, can be exported to different parts of the world. And today what has happened, India has gained tremendous amount of trust among African countries, amongst the other developing countries. And I think, I'm not being judgmental and not being political, but at times also the feel is that a lot of things come from West, right, wrong, good or bad, the perception is that, they want to colonialize. Okay, I'm not again being judgmental here, but I think sometimes these are the things. India has enjoyed tremendous credibility. Some groups like Tata's have created a lot of good vibes overseas. There are companies and there are companies. I wouldn't go into the details discussion, but I think it's a great job. I think Aditya ji, maybe I can ask you a few questions if it is possible. Are you online?
Yes, Mr. Desai.
Yeah, thank you. So, could you just give us some updates on the supervisory activities undertaken by IFCA in the recent times? Because I think there are a lot of improvement, a lot of refinement that you brought into. So, if you could just give us some update onto what's happening and I believe even the expeditious processes have been introduced somewhere on the line. So whatever you could update us on what's happening there, it would be useful.
Right. So I'll start with the point where you left off. It's that every jurisdiction these days require substance. And it's the same thing which the GIFT IFSC and the IFSCA also expects from the regulated entities. So the IFSCA has been entrusted with the task of developing and regulating GIFT IFSC as a financial center. And while this is an ongoing task, development is not a one-day job. This will go on for a long period of time. The task of regulating requires us to wear the hat of a traditional regulator as well. And as the size of the industry grows, like I just mentioned, that there are more than 130 FMEs which have raised more than 12 billion worth of commitments from their investors, and also invested a significant amount across different jurisdictions. So this industry has grown at a very significant pace. Therefore, with the growth also comes the expectation of the regulator that the laws are complied with by the FMEs in letter as well as in spirit. And while we trust our FMEs for the same, we have created certain mechanisms for the off-site and on-site supervision of the entities. So last year in the month of May, IFSCA issued circular which laid down the reporting format for the fund management entities to provide periodic information to IFSCA. This found to be very stale information, therefore the frequency was updated and made on quarterly basis. So now all the FMEs are required to provide information on a quarterly basis, which is then analyzed internally by the IFSCA, and wherever actions are required, we take those actions. We further seek explanations from those FMEs. If there are any policy-related inputs which we gather from these reports, then those policies are also taken. For example, there was one issue related to the net worth, which was found to be very recurring in FMEs. Many of the FMEs were found to have non-compliance with the minimum net worth requirement. Now, net worth also constitutes to be one of the core substance requirements, in addition to the manpower, the infrastructure, etc. Therefore, not having the adequate amount of net worth raises multiple concerns. One, that of substance, and another, that of the risk management within the fund management entity. Therefore, on this observation regarding net worth, IFSCA issued a circular in which business restrictions were placed on those FMEs which do not meet with the net worth requirement. While IFSCA will continue to reserve the right to take actions as deemed appropriate, as an interim measure, these FMEs were stopped from taking any new business, onboarding any new investors, or launching new schemes, etc. So this sort of supervisory measure was brought into action. So this is off-site supervision, which I'm sure all the entities which have experience in being regulated from the domestic market or in the international markets would have already experienced. Then there is another dimension of on-site supervision. We have carried out on-site supervision of several entities last year as well as this financial year as well, and this process is likely to continue in the coming years also. So what this has provided us is an opportunity to interact with the FME in a more closer manner, understand their processes, look at their records, their documents, their internal processes, and wherever required, we have shared our observations with the FMEs and asked them to take corrective actions in a time-bound manner. Many of the FMEs have done so, and those who have failed to take these actions, we have taken regulatory actions against them. And one thing that we have done largely to ensure that the FMEs present in IFSC meet the substance requirements is to undertake surprise visits to their office premises. So on a random basis, we do some surprise visits to some of the FMEs. We have done this in multiple phases in this year. And we have found that many FMEs despite being registered with the IFSCA and despite having operations as well, did not meet the requirement regarding presence of manpower or having commensurate infrastructure. So we have taken actions against these FMEs because these are violations on multiple grounds. One is that of the regulation, and second is the expectation of having minimum substance in IFSC. So I hope this answer has provided some insights regarding the supervision of IFSCA.
Thank you so much. And any further thought on what is likely, or is there some overall of fund management regulations that are likely to come? What industry can expect, or what the industry expects from our side? But I think if you have any thoughts on that, that would be also helpful.
I'm sorry, Mr. Desai. Could you repeat the question, please?
No, we understand there may be overall of financial
FME
fund
regulations.
management regulations. Can you shed some light on this and on what the industry can expect in coming months or something that's happening, if it is possible to share?
Right. So, of course. So like I said, one of the responsibilities entrusted to IFSCA is the development of the jurisdiction. And in that process, in discharge of that responsibility, we extensively engage with the market participants. We participate in a lot of industry conferences, roundtables. We in fact organize many of them, in addition to the one-to-one meetings that we frequently have with the market participants. So all of these forums provide us an opportunity to take useful feedback from the market participants regarding our regulatory frameworks. And I'll talk about the fund management regulation here. And last year, in the month of October, we issued a press release requesting public in general to provide their feedback on the fund management regulations. We received several suggestions, and the ongoing process of interacting with the industry has been going on. We have also organized several sessions of Chintan Shivir, which basically involved interaction of senior management of IFSCA with the senior leaders in the fund management industry. So these sessions have also provided us quite a lot of useful feedback regarding our own regulations. So taking into account all these inputs, what we have done is that we tried to amend our regulations in a way which address a lot of the concerns which the market participants have expressed across these forums. So in the month of August this year, we issued a consultation paper clearly laying out the draft text of amendment to several provisions of the fund management regulations. These amendments were largely intended to provide larger ease of doing business to the fund management entities in IFSC. There were also some amendments related to investor protection and clarification, but the bulk of those suggestions were related to the ease of doing business. And we have received significant numbers from the industry, comments from the industry, and we are now in the process of reviewing those suggestions. And we hope to take these suggestions to our board in the next board meeting. And as and when the IFSCA board approves the amendments, you will see a revised set of regulations on fund management in IFSC. And I hope a lot of the revisions that we undertake will lead to further ease of doing business, more flexibility to the fund managers, and to innovate, to bring and introduce new products for their investors.
No, wonderful. Thank you so much. One other question is, IFCA requires certain employees of the manager to be based in the gift city. Could you give us some insight on what constitutes based out of gift city? Is there some thoughts, or I know you'll be able to get some insight into this. How do you look at it?
No, I don't think this would require even a response, because this is so logical and self-explanatory that any entity which is supposed to be based in IFSC and which is designated a couple of people to be the key management personnel for the entity here, So the general expectation that is there is that those people would be present here for the large part of their work, right? So there are questions related to travel and personal leaves and all those things, which architects would travel for the business, for their personal reasons. That is all acceptable. What is expected is that the PO and CO are predominantly based out of IFSC. This is their place of employment. This is uh, the FME entity in IFSC is the entity. These are the general expectations, which I'm sure any logical person would be able to infer just by reading that provision.
No, absolutely. Thank you very much for excellent response to this question. Because ultimately it boils down to good faith and a logical place of work in the gift city. I think the whole idea is that people should be working out of it. We all understand where we are working out of, But thank you so much. And could you also elaborate on general timelines and process?
And if I may interrupt Mr. Desai here, the idea of IFSEA, and I'm sure the market participants who are present in IFSC, is to create a vibrant ecosystem in the GIFT IFSC. Because this is the place where this is of course a project of national importance, and this is an experiment of a new kind, and all those people who have set up their bases here, they are as much exposed to the reputation of this jurisdiction as the regulator is, or any other person. So having this place developed as a vibrant ecosystem will add value to each and every entity who is invested in this place. So the expectation of the regulator to have some people who are based here, who can who can be the front, who can be the faces of the entities operating out of this place, whom we can call and have a discussion if there's any query that we have, or if there are investors who visit in GIFT IFSC, there is someone to represent these entities. So this is the general expectation, which I'm sure any reasonable person would be able to understand and sympathize with.
No, absolutely. I fully gather. I think we have to look at substance in a substantial way, and I think we have to have more robust base out of GIFT City. Otherwise somebody will say they are using only for tax purpose or some other manipulation purpose. I think that again it cannot be defined. It can only be described to some extent, and one has to understand that what is the intended provision for this purpose. So thank you so much. Can you just elaborate on general timelines and process for approval of the funds now? What practices have IFCA been seeing developing in terms of registration of FMEs?
Right. So, so one of the things which I'm glad to inform, and I'm sure most of you would already know, is that the non-retail schemes, that is the AIFs of the world, have been allowed the convenience of green channel now, and this has been there since April of this year. So what this basically means is that any fund manager which intends to offer a non-retail scheme now does not require to wait for the approval of the IFSCA. They can simply file their scheme documents. There's a circular out there which gives the details of all the things, all the documents which are required to be filed. So once they are able to file all those documents with the IFSCA, they can immediately go ahead and launch their schemes. And in a very short period of time, IFSCA will revert with a communication regarding taking that scheme on record. So what this basically means is that fund managers can now plan their offerings in a more seamless manner, because the time which typically the regulator takes, which is considered to be the biggest period of uncertainty in the overall timeline, is now taken away. It's been completely shrunk. So all the schemes which non-retail schemes which are filed to IFSCA are approved in a very short period of time.
So thank you so much. We have about 10-15 minutes. So maybe Aarti and others, you might have some suggestions or some ideas.
There's a panel discussion that's happening.
Oh, that I thought this was
we
all.
can continue.
Yeah,
with the
no, we can continue from where we left.
Yeah. So therefore, I said it might be a good idea to
Yeah.
interact and.
Okay, and Aditya, please do stay because it is a very good intervention which you gave. Very well answered.
Sure.
Clearly, I think Ifska is right in saying India has always spoken about substance. So in all fairness, I think Ifska is demanding substance. It's very clear. Coming to, I think Nishith Bhai clearly has said about the laboratory, and one of the best laboratories on all this is NDA. Let's go to the scientists there, Parul. And we will, as a continuation of what Sudeep mentioned, we have heard from the regulator, we've heard from the fund manager. Let's go and dive a bit deeper. Taking up from what Aditya said, the recent regulatory changes such as enabling 100% participation of NRIs, OCIs in IFSC-based FPIs, and also extending the LRS scheme to recent individuals into FSC, all has been very pivotal. But tell us, Parul, how can regulators, particularly IFSC, further support the growth and scalability of the fund management ecosystem in GIFT City?
Yeah, no, that's a very pertinent question. Thanks. And I think you mentioned, using GIFT City for outbound investment purposes. And actually, we are seeing a lot of people who are interested in GIFT City for tapping Indian capital and using it to invest overseas. Of course, that's all within the RBI framework and the overseas investment regulations. I think, so first, the good part, and we've talked about the changes that have come out on the NRI front as well. The good part is that, investment is permitted by, let's say, Indian family offices up to 50% of their net worth, which is not really permitted in any other jurisdiction. That by itself is a very big reason for someone to set up a fund in GIFT City for investment outside India. I think there are a couple of challenges, which would be great if, IFSCA can also work with, and, we can talk about those. One is that, the biggest challenge has been mobilizing Indian capital for investment overseas. Now, when there is an AIF set up in India and the AIF can take money from overseas investors as well as Indian investors, this AIF may want to invest in India and outside India. And investment outside India is, we know the restrictions, 25% of corpus, the ceiling has been breached, you need to go to SEBI for an approval, etc. Mobilizing Indian money for investment outside India has always been an issue. We have seen situations where actually this is all permitted within the RBI framework, that Indian money can be used for making investments outside India. Let's say investment into a gift fund which invests directly outside India. I think what would be really great is if, we have this concept of excused investors. Right, and we know, and Aditya can probably comment on that if needed, that IFSCA doesn't really like Indian money going into a gift fund and coming back into India, because probably that's not the reason why the entire, gift framework has been set up. But in order to make this, life a little bit easier for fund managers, maybe a structure can be, considered where you set up a gift fund, and which pools in investments from money from overseas investors as well as Indian investors. To the extent the fund is investing in India, the Indian investors are excused, and to the extent it's investing outside India, the entire fund invests outside India. So this is a kind of a midway between excused investors and the blind pool concept, which which regulators ideally want. So if something like that can be considered, probably, it would make structuring a lot easier. We are seeing how people are setting up actually two parallel gift funds, one for investment in India, one for investment outside India. But it just makes the administrative hassle and the cost of doing everything really go up. So I think that was one point. And I think the second point is actually, there are RBI regulations, and there is an in-spirit thing behind what RBI wants and what the regulations really are. Everyone understands, and we've been talking about substance quite a bit, that in substance you need to comply with overseas investment regulations. But if regulations are permitting, for example, investment going into a gift fund, which may be investing outside India, part of that money is coming back into India, but it's not really meant for misusing any of the regulations, but it's investment into a fund which has a global strategy. And there are many ways to figure out that whether it has a global strategy or it's just set up for investment into India. Maybe some work along with RBI if needed, or some work that can be done to ease this. Probably that would take the gift structures, to a next level and open up more, investment from Indian investors into the Gift City Fund.
Okay, I think there is an opportunity here for Aditya to intervene, but let me pitch a little bit what Parul has beautifully brought out. A country like India, which keeps on building reserves, any investment of India outside is equivalent of not putting it into dollars. This is what GIC does. You need to actually, the way of diversifying our assets, the better way for a country which is getting wealthy is not keeping it in dollars and gold, but actually putting it assets of other countries. So in that context, GIFT actually allowing Indians to invest more in assets abroad is a very important thing. So in this context, Aditya, how are you going to, I think you can respond to a little bit more flexibility on the round tripping issue which you all have.
Right. So one of the things which the lady here said, sorry, I am.
Parul is the part.
Yeah, yeah. So one of the things that Ms. Parul said is that one of the core principles for which IFSCA practices, and I'm sure you'll also agree, the purpose of having GIFT in place in the first place itself is to bring onshore what was there offshore. So prior to GIFT coming into picture, a lot of India-focused funds, India-centric funds were basically being set up in other foreign jurisdictions. We all know their names, so I'll not take their names. But that was a lost opportunity which India was missing on. And to bring that opportunity home, the concept of GIFT comes into existence. And that is what we are doing so far. That is the principle that we are following in all our decisions, in all our policies and philosophies. So allowing Indian money to come into IFSC and going back into India is not something which gels well with that philosophy. Because there is a domestic market, a very vibrant market, which is regulated by a fellow regulator, the allowing that kind of flow to take place is simply, going into the turf of the domestic regulator, which anyways is pretty well regulated. There is no reason for us to interfere in that. However, what you mentioned about Gift City coming or emerging as a jurisdiction for Indian investors for taking global exposure is something which we also completely agree with, which is also allowed by RBI under the overseas investment rules and regulations. So that is a great opportunity, considering that the investors in the domestic vehicles are constrained by the limits of $7 billion, $1 billion, which are already there, and most of which are exhausted or close to exhaustion. So there is no such limit in IFSC. So there is an opportunity for the fund managers to explore offering those kind of products to their resident investors, which allows them to take global exposure. But to mix and match and to mingle all of these type of flows is not something which we would feel comfortable with.
I think one small thing here, just a perspective, that what happens when we raise funds abroad, they also want the Indian skin in the game. So typically 60-70% of the investment comes from abroad, 20, 30, 40% from India. So assume for a scene that Gift City Fund has 60% foreign investment and 30-40% Indian investment. And assume for a moment that some portion of it is reinvested back into India, then you are getting 60% of foreign investment alongside India. So we should think that way, that if it is a catalyst to bring foreign investment, and then remaining Indian investment will go outside. So we have to, if it is possible, it might be, it's a midway.
No, I'm glad, Mr. Desai, you raised this point, and I'm happy to inform that this has already been done in the regulation. The regulation already allows up to 10% contribution from the FME or its associates in the scheme. And in this case, the nationality or the residency of the associate or the FME does not matter. So even if the FME is an Indian FME, the shareholders of that FME are Indian residents. Yeah. Even they can bring up to 10% contribution to their IFSC schemes, even in those cases where the scheme is investing back into India. So there's a specific carve out just to facilitate or catalyze these kind of things. We understand that a lot of investors insist for skin in the game from their managers, from their GPs. So just to facilitate this kind of situation, the regulation already provides for it.
So Gift City Fund can invest up to 10% back?
Not Gift City,
No,
the
no.
fund manager.
Fund manager.
Fund manager.
Sponsor
manager
Up
is
to
fine.
10% of the fund.
But one is fund manager, but
Yeah.
Indian investors, because they want to pull the whole thing.
So then actually the taxation and all will come into
In
picture.
fact, taxation can be, of course, now
That's
fortunately
more.
tax has become neutral. Tax rate have been, one great thing that happened in this last finance bill was to streamline the capital gains taxation. I think it was so difficult earlier to explain to people the provisions of capital gain, people getting completely confused. Now it has become a lot more easy. Same tax rate, whether you have capital gains from abroad or from India, there is not much difference. You anyway pay those taxes. Indians are taxed on their worldwide income, no problem. So maybe it's a time to revisit this particular issue. I'm not asking you to right away give us an answer for that, but at least it will be useful to have discussion about the benefits of, having a joint pool of money from abroad to in India and some part going outside. Because Indians get opportunity to co-invest in the overseas opportunities, but some portion of it may come back irrespective. Tax is not a problem because tax rates have been streamlined now. And so to some extent things have changed after our capital gains regime has improved. Maybe this is one suggestion to just reconsider, and maybe we are here to help.
We'll surely.
Sure. So I'll take this feedback.
Yeah.
Just since we are on that outbound strategy, I want to ask Aarti, because who's more on the product side. How do we popularize this and take it to the next level, Aarti?
No, thanks. I think we at 361 we've been very, very active in Gift City, both inbound as well as outbound. And I should say one thing for IFSC, they've not only been exceedingly approachable, they are listening. So if you read the draft of a consultation which was circulated and some of the suggestions, it tells you that they've really been listening to market participants. So and we operate both out of Singapore and out of Gift. So I have a very direct comparison, because every time we decide to set up a vehicle, there's always a conversation around where should we do it. Obviously, for the outbound, Gift has a very, very big advantage in terms of the allocation can be far higher. So there are a few things which, if cleared, will help. So, for example, in other jurisdictions, there isn't always a minimum requirement. IFSC has a first close requirement of $5 million. What that means is, and I think the consultation paper proposes to bring it down to $3 million. But what it basically means is, if I have a client with a $500,000 check, I need to tell him, wait, hold on, let me get the other $2.5 million as well. I don't believe that any other jurisdiction imposes this on us. One of the big advantages I have in Singapore is I can take that 500,000 and then sort of build it up, right? So that was one. And I think there are a few which are not necessarily IFSC related. One of them is taxation. Category 3 AIF taxation has always been complicated, even in domestic. But I think what complicates it a little further for Gift is that in international securities, the gap between short-term and long-term capital gains is huge. Long-term is 12.5 plus, short-term is nearly 40. So in that churning and FIFO, we're unable to give clients sometimes clarity, particularly in the open-ended funds. Clarity, because they don't know when they come in to redeem which units are getting redeemed and whether they will be in short or long term. So there are some operational sort of tweaks of that nature, and like I said, all of them are not IFSCA dependent. The third one is this whole SEZ Act, right? The fact that we have to go set up a trust, whether it should be one trust multiple scheme or one trust one scheme is still grey, so people go conservatively with one trust one scheme. But what it basically means, it adds an additional leg. I have to go set up a trust for every scheme that I want to launch. And I think even in terms of cost, right? For people who are set up and already have substance in Singapore, to add incrementally, it's not that expensive. So when people ask me, is gift cheaper? Yes, sure. If you didn't have jurisdiction set up elsewhere, then gift is a very good affordable option. But if I have Singapore set up, then what I'm doing in gift is every additional strategy I'm paying $22,500, and I know that there was a proposal in the regulatory framework to say how do we bring that down. So these are some of the things, and they're not all related to IFSC. They fall with various other regulators, acts of parliament, taxation, SEBI. There are various aspects involved, but those are some of the things where if we were able to tweak around, I think it will really give a fillip on the outbound side.
Thanks, Aarti. That's a practitioner's point of view. Aditya, we're not going to put you in a spot by putting all this on your plate, but these are certain aspects of how we can popularize this, and I don't want Aditya to be always on the spot. You want to respond?
Thank you very much for that.
That's not fair. We didn't call you for that. This is more for you to have a fireside chat with Nishith Bhat. So I'm going to leave him off the hook.
No, to be honest, they've all, like I said, if you read the consultation paper, you will know that they've been listening. They're acutely aware of all these issues. It's just that in a multi-regulated scenario, there's always bounds to what you control. The other thing is also digital onboarding, right? So the one of the things we struggle with on the inbound side, I know your question was with outbound, NRIs don't have Aadhaar card. They don't have a digital signature. I can't do an OTP based Aadhaar. And can I do DocuSign? It's actually grey. So some of those aspects will certainly result in debottlenecking.
One thing is IFSCA is absolutely listening regulator. With always a cap on promotions. I'm sure we will take, and DocuSign and all should be accepted for sure. It's a global thing. Let me put Atul on the spot with the regulator there. I'll ask a cheeky question. I think Atul, of course, is very familiar with global private equity jurisdiction. So, from a regulatory perspective, Atul, what ecosystem which is prevailing elsewhere is not available in GIFT, and what can you add in terms of how it could further evolve the GIFT jurisdiction? I know you are heavily invested as a service provider.
This is really tricky, especially when Aditya is there, and I think partly he's already replied to some of the points which I wanted to raise. I don't think it is, and this is not a diplomatic answer, it is right to compare one jurisdiction versus other right away, because other jurisdictions have come up over a period, decades, right? And we are relatively new, and what we see in another jurisdiction was not available in those jurisdictions on day one. It has evolved over a period. We see, Cayman and Jersey been revising their various policies from time to time. And therefore, in India also, it's not going to be different. We would evolve over a period of time. It's more like a discovery approach. And I think it is a collective, before I answer that question, it is a collective responsibility, not just from a regulator perspective, but from an industry perspective as well. Like, the GPs also need to bring a lot of changes. So are the service provider. Of course, the regulator is always there because they drive the growth of the business. And in India and elsewhere as well, there's not just one regulator as far as the fund industry is concerned. Obviously, there is an income tax aspect, there's a FEMA, and so on and so forth. So collectively, a lot of things which are there elsewhere can come here, and which could help further growth of the industry per se. To be more specific, I think Mr. Aditya has already answered, but let me touch base with it. We spoke about substance, right? That obviously we need a PO and CO to be present there, and the regulator does the inspection, we hear that in the right spirit. But I mean, globally we see that some of these functions are outsourced. So you can have a compliance function outsourced, you can have a principal officers outsourced, even the management companies outsourced. So there are advantages and of course the disadvantages. Not that everything can be made available in India today, because we are into a different ecosystem. We have a different ecosystem, and the circumstances in which this IFSC is being built is very different than the circumstances in which the other foreign jurisdictions have evolved over a period. So I think that could be one. The second being, we see a lot of emphasis on, we see a lot of products being developed for investment into pure private equity. we see now a lot of opportunities coming up for investment into private credit in India, structured credit in India, outbound also into private credit. A good amount of strategies being built for fund of fund now. Those especially the alternatives which comes with the mutual fund backgrounds also come up with fund of fund. Though fund of fund looks like a simple structure, it has its own complications in terms of how we would have the management fee calculated and so on and so forth. So I think some guidelines on that, and I understand that no regulator would get into how we would do the accounting, how we would do the reporting, how that should be done. That is left to the GP or the industry per se. But a certain guidelines there and a uniformity can always help. And the last thing I would say, because the other things have been already spoken, a kind of some concession, which is where the country like India needs it, and in foreign jurisdiction we have seen how that has helped the growth of those countries, some of those countries, is the infrastructure, the real assets. We're talking about the real estate but not the real assets. So you could have strategies and incentives given to this sector or this set of funds, which could have, where the money could go into the port development in India, which could go to the aircraft leasing. I think IFSC itself is more a lot of focus on shipping and aircraft leasing. I think one of the suggestions on the group of people who were working on how the aircraft leasing and financing should be structured out of IFSC, one of the suggestions that had given was as to why not have a fund having an aircraft leasing and financing. It could be futuristic because we are still not in that, we do not have an ecosystem developed around it. But the real estate is there, but the real assets, which is hard assets, need some incentive, and if IFSC can look into it, that would help further growth of India, in the infrastructure space.
Oh, you covered quite a lot. I think we have to take cognizance that IFSA has taken a big step compared to the onshore, where there is absolutely no regulation of the intermediaries. They have created an ancillary license under which IQQ operates, which is actually a big step. I'm very surprised. There is no such regulations in Singapore, in Hong Kong. It's a wild west. The intermediaries are not regulated at all. And that way, IFSC is ahead. It is almost going in the line of Luxembourg and others, where the intermediaries are regulated. Because regulating an intermediary is cheaper regulation. Because you have an entire set of people deploying compliance in line with the regulator, and the cost of them is eventually charged back to the investor. So there is a smart way IFSA is going, which SEBI is not done here, which we need to speak to them. So thank you, Atul. I want to come back to Parul and ask, I'm now going into a wish list type of thing. If I say, what are the top 2 changes you would like to see under the fund management framework in GIFT? And I'll wrap up with a round of questions.
Sure.
You all can keep it within 2 minutes, because I think...
Sure. So I think some small changes which are feasible actually. Aarti spoke about some of the issues that are, some niggling issues. So, and Aditya spoke about the net worth and how, inspections have been happening to make sure net worth requirements are being met. The net worth requirement is, it could be $500,000 for a restricted category, registration. Now, if you look at the way an FME is set up, it actually doesn't have any need for money. I mean, it's getting management fee, its expenses are being met. And, you have people who are employed there. They are not really the GP level people. They are people who are compliance people. And of course, all compliance of FME regulations is also being met. We have faced, issues from our clients which are saying that, you need to meet this criteria on day 1 as soon as the entity is set up. Of course, net worth also includes the sponsor contribution that is put back. But many times when there's an AIF, then you don't need to put in the sponsor contribution. That can be just directly put in by the Indian manager into the AIF. So maybe some tweaks around the net worth requirement, maybe at the parent level, which is already there for a branch, and it needs to be earmarked, which is also, a question mark. What do you mean earmarked, right? I mean, do you need to get a balance sheet done which says earmarked for and cannot be used? You need to put it in an FD. So some tweaks around this issue would really be useful, and I think that's one of the things. Around the substance part, I think we've had a lot of discussion that we need substance. We This is not really some tweak, but some clarification or something. Really, I mean, so what does really substance mean? In the sense, we've spoken about two people. The regulations require that the investment decision should be generated from the IFSC, but there is always this tug of war. Is an IC good enough, which takes the decision? Actually, is that substance good enough? We've had situations where our clients have said that we need substance in GIFT City. If you don't have substance, then what happens? I mean, actually, if you look at it, there is no tax benefit, contrary to the perception that there is a tax benefit. GIFT City is very good because you are at par with investing from, let's say, Singapore fund or a Mauritius fund. Tax benefits there for debt investments and all. Equity, there is no tax benefit. There's a tax 10-year holiday for the manager, but that money ultimately comes back into India. So what are we really looking at substance for? There's a GST exemption, but and people are not really setting up in GIFT City for tax benefits. I think that's one thing that we need to realize. People are setting it up for operational benefits, the cost efficiency. And regulators are very open, are approachable. You want to be in your country, so I think some clarity around that will also help.
I think the last point is very important because you made a bold statement here. Because when the treaty was taken away from Mauritius, we thought fund business will come down. It didn't. So it is the ecosystem which is more important than the
Correct.
tax, particularly for private equity.
We don't have any clients who are setting up in GIFT City for tax. Let's put it like that.
Excuse me, may I just re-emphasize one point that Parul said, and just Aditya is here. I think she said, he might not be able to see me, but she said a very important point that net worth requirement, there is lack of clarity around it, while it can be earmarked at the holding company level of domestic.
Only if it's a branch.
Entity.
Only if it's a branch.
Only if it is a branch. But why is the earmarking requirement even there? If let's say the domestic company has a net worth of 10 CR, why should it need to be earmarked for the GIFT City? I mean, there isn't any big rationale, and as you said, the costs are already contained. There is surplus generation of revenue.
Yeah.
So I think that can really boost the operations. And I think she also mentioned a very good point about the investor onboarding complexity of NRIs. I think these are the two important points.
We should note it down. Maybe what we should do is we should pocket with Parul.
So if I could,
please
if
go
I
ahead.
could respond to this.
Go ahead.
Yeah. So net worth is one of the ways in which regulator tries to ensure that if something goes wrong within a regulated entity in course of its operations, there is some capital to make that wrong right. We have seen in so many cases on the domestic side as well as internationally that entities engage into some practice which is not really in line with the regulations. The regulator takes an adverse view. The regulator takes that entity through the process of enforcement and everything, and at the end of which, in a lot of cases, there is penalty which is imposed. If the entity does not have the net worth, how will it pay that penalty? Penalty is, it's not that the regulator has the job, the entire job of the regulator is to charge penalty, but one of the jobs that the regulator has to play is to set wrongs right. And one of the ways in which it can do that, other than debarring the entity from the market, is to impose monetary penalty, which I believe is a softer penalty than entirely debarring that person from the market. But for us to be able to exercise that power, we require that entity to have some sort of capital.
I just have a view over here. I think everybody is talking about more of large funds, and we are at a cusp where the fund life is just getting over, and we are looking at extensions. As a young fund manager, as well as a very under $20 million fund, right? We have lot of licenses which are being issued. Lot of fund managers who have managed large funds are stepping out and starting their own funds, right? Lot of domestic capital is definitely available, but lot of international capital is waiting to be invested in India, right? And as Aarti said, and Parul said, there are multiple angles where inbound of capital needs to be eased out. However, as a micro VC, now it is, when we are looking at these capital coming in, right, we have two options. One is going to a Singapore-based fund, which is mostly a feeder fund, right, or a gift city-based fund. I feel that we should also focus on tier-based rules, regulations for micro VCs, which are going to be eventually getting more capital. And fund life is like 15-20 years, where you keep rolling out funds every 2 years, right? But this is probably a right time for structuring and making attractive propositions for micro VCs like us, who eventually would experience or start off their journey with Gift City, but eventually the next fund would give you the larger corpus, as well as we would have an experience there.
So it's a product suggestion.
It's actually a tier-based piece, right? Because it would cover the 10 crore piece also, it would cover the digital onboarding also, it would cover the domestic capital moving out. I mean, we have stopped investing outside because of the LRS issue, right? That doesn't mean that we won't be doing that, but we might be enticed to open a fund in Singapore versus a gift city, right? So I think it's a tier-based approach, which I would love to see.
I would say, Parul, someone should collate these things from today's recording.
We are taking notes.
These are good inputs for all of us to take in, so we shouldn't let these rabbits just go away. Thank you very much.
No, this will be very helpful. We are part, I think, of innovation committee as well at IFCA, and they are constantly looking at innovations, improvement, and things like that. I think it will be useful to get.
Sure.
And unfortunately, one of our colleagues, she leads Gift City, Radhika Parekh, she got down with pneumonia and could not join. But Prakhar is here, and they are all here to help you out.
We will park it in the safe hands of MDA.
So if you can write to us, and we can incorporate, articulate, and then circulate around.
BVA actually give that platform to upcoming fund managers, with having that minimum around 5 to 10 investors minimum. Their corpus size is also very small, who actually initially started their funds. So BVA actually that give that opportunity, British Virgin Island. So that is actually least regulated activities for that particular entities. But that will give platform to that upcoming fund managers.
See, other interesting thing that happen on a global basis, there are large number of islands and large number of jurisdictions which were covered under what is called FATF. If you see last 2-3 years, number of jurisdictions have improved their processes, and there are like Mauritius at one point of time was there, UAE was there, Cayman Island was there, BVI was there. They all are streamlining and cleaning up the processes. So that is what is another development we need to bear in mind. There are more players going to come, because what is there for BVI and Cayman, it's just the platform. Okay, nobody is establishing substance there, but the ecosystem they develop and the brand that is developed, I think that is where. So I think we have to see how best we can make sure that GIFT continues to be attractive place.
Let's take a product which is spoken about everywhere. It's a big success in Singapore. Mauritius has copied it well and started doing well. So I'm going to ask Aarti about VCC. And do you think GIFT should also come up with something similar to a VCC structure because of its ease and adaptability, and it's quite like a product which can be applied in different places. Aarti, any thoughts?
So I think the only difference between a VCC and an AIF is in its legal structure, right? A VCC is a corporate structure, and AIF is more of a trust. The Singapore VCC, and Mauritius is similar, has a set of advantages, some of which are already available to us in GIFT. So I'm not so sure about VCC. So what are the benefits for investors coming in through VCC structures? Firstly, mirror, right? Particularly for Indian families doing LRS, it works very well, because often what happens in LRS is when an opportunity is cited, one family member will put $200,000 and buy NVIDIA. The next time the second opportunity comes along, you'll have subscription number 2 going elsewhere. And over long periods of time, we find that our families have portfolios which are looking vastly different from one another. So firstly, I think the mirror and the idea of having all your holdings in one place. I think having a VCC structure also helps in that you can pool into a pool strategy, and the disclosures required in the ITR are very simple. So inside that fund there could be 25 securities, but you're just holding units of a registered fund, because a VCC in Singapore, while it has a corporate structure, it's defined as a collective investment scheme. So so there's some of those benefits. I think Singapore provides a tax benefit, which is very, very key, right? So if you have the substance to get your 13R, 13O, 13U, then it works exactly like a mutual fund, which today, we don't have in GIFT at all. So if we can replicate all of those benefits in the manner that they exist under the FME guidelines, because the VCC does say that it has to be regulated by a permissible permissible regulator, in this case MAS. Where the fact that your discretion and your investment decision making is being done by the manager and not by the participants holding units in the VCC is very, very stringently monitored. So those are some of the benefits of VCC. But more than VCC, I think what we are missing in GIFT is the framework exists, but I think the adaptation of an omnibus, that is really the one thing, both in terms of having an omnibus jurisdiction within GIFT, because that is pretty much how the whole world operates. Every private bank operates through an omnibus. So if you look at large clients who come in, even into GIFT strategies, they will come in through a Clearstream or an All Funds, or whoever is the custodian for their private bank. There again, some of the operational challenges that we see is, we recently had one of the omnibus players tell us, I don't recognize Indian ISINs. Right? Because I have funds in GIFT City which have their own ISIN. Ideally, it should make it extremely convenient for an NRI with a private bank to simply place an order using the ISIN. So on VCC, like I said, I think there are some benefits, many of which are already replicated in the IF structure. But if we can solve for it 100% and make it a replica of the Singapore VCC, which will obviously involve consultation with tax, consultation with company law, etc., then I think that's going to be very useful. Plus, I guess more widespread understanding on omnibus, because omnibus effectively means I cannot KYC the UBO, right? I can only, it's a subscription coming to me through Clearstream or through All Funds. I don't know who the UBO is. The private bank will not share that with me either.
I think it's a very important point, possibly Aditya, to park it with you. Let's leave the VCC, because VCC, it's created this, because I run the region, and I've traveled 4 times to Hong Kong. I'm seeing what's happening, particularly with respect to the family offices in Singapore. I think GIFT, while GIFT was set up for funds and it's as a major trading hub, Paul mentioned they've already gone to 100 billion per day. Here is a great opportunity on private wealth. I think one of the strategic streams which IFSCA or IFSC should think through is how to actually become a private wealth hub. When I say private wealth, actually the family offices, the whole aspect of which was touched upon by Aarti in terms of an omnibus, because I think GIFT can play a big role in becoming India's private wealth hub, both in and out. And it is not necessarily that there is actually a convergence of funds and private wealth. And I'm seeing it now in Singapore. Bulk of family offices are using the VCC, and each cell is for one family. And who's running it is an ex-fund manager. Actually, it's a fund.
It's a fund.
It's actually a fund. So just parking it with you, many of these conversations are very interesting and can go for a round table for 1 hour, 2 hours. So we leave that with the able hands of Nishith Desai.
Maybe I can add a little story, because I got a lot of. This is my 50th year of legal practice. Fantastic. Hopefully, I don't look that old.
No, you don't.
But sure, no?
You don't.
Okay, thank you.
You wrote a book.
I'm flattered. So, see, history of trust is like this. Globally, you have got LPGP structure. Now, what is limited partnership, right? So, original form of business was proprietary. Then 2 people came together and they formed a partnership. So, everybody has unlimited liability. Then came in England the form of LP, where limited partners are there, but one is a general partner who has unlimited liability. Then came LLP, every partner, because professional services firm particularly started talking about that why should one particular partner take all the liability. So LLP came in. In the US then came LLC, okay, and now there are many other forms that are there. US continuously coming up, and some jurisdictions continuously innovate new ways of doing things, right? Now what happened in India, we did not have this VCC, even VCC in Singapore is little new anymore. We didn't have protected cell companies, we didn't have other forms of. Now what happened when first fund was to be set up for ILFS and AIG, and we were looking at it, I was thinking, then it occurred to me that we can use trust structure, and in India the law was clear because of the case law, I would say technically 108 ITR, of AEH Nizam's case. So they had 108 family members, each one had a specific share in the trust, and tax department was trying to treat it as a separate entity. So the argument was that if there is a specific share of a person and he is determinate, so all this kind of thing, right? So then trust will not be taxed as an entity, but each beneficiary would be taxed, okay? So there was a clear ruling. Mr. Palkiwala argued, I was those days working with him as well. And so there was a clear case law on the subject that if there is a specific beneficiary, specific shares, okay, identifiable and all those kind of thing, then it can be a pass-through vehicle. So we set up first trust. In Mauritius, it was all company we set up, okay. There is another story. But the thing is, in India, we set up trust, and then I and Soli Dastu were talking. Soli was one of the iconic seniors for us, right? And I said that we can use the same structure to create a first fund, because most of the experience was in the US, and I said the US is LPGP, but we don't have a limited partnership. Okay, that concept of LPGP doesn't exist, although I keep on talking about it. So we created this structure, and we thought this first time is a guinea pig, large amount of foreign investment, first private equity fund coming into India, and so let's go to advanced ruling. So we went to advanced ruling authority and got a clarification that this is a specific trust, and therefore trust will not be taxed, but each individual beneficiary will be taxed, and there were beneficiaries who are Indian residents, and also they were from Mauritius and other places they were investing. So we said if it's a pass-through, then even treaty benefit between Mauritius and India should also apply, because these are look-through structures. So you ignore trust for the purpose of taxation. So it was look-through. So we applied a Mauritius-India treaty in the AIG case, and advanced ruling gave us a ruling with advanced ruling authority comprised of Supreme Court judges and all that. So it was very high level decision. So it established a principle that yes, you can even look through the trust to apply treaty. So that's how Mauritius investors got treaty benefit with India, even though it was invested through a trust in India. So trust became, and I love trust for one single reason, because it is a very simple form, old type form. Whatever I write in the contract between settler and the trustee is my law. So I can create units, I can do this, that. One of the problem I was just intervening, I'm sorry I'm going a little long, but I'm giving you history. In Mauritius, what was happening, first fund that came up was Bombay Fund Limited, Barclays Resort Investment Management. That was first FI. Second one was Alliance Capital. Okay, and that point of time, the fund was set up in the form of company, and Mauritius also had old English style law that if you have to return capital or even declare dividend, then it can only be out of the profits of the company and not out of the classic English law. Now, if suppose fund makes a loss, how do you return capital? Okay, so therefore suggested to change the law. So we changed corporate law in Mauritius and made it that you do not necessarily have to return capital out of the because fund you don't know, it may be loss or whatever, right? So therefore return of capital is important part. So that was changed. But in case of trust, you can do whatever you want to do. So I'm just giving a little background as to how the history has evolved over a period of time.
No, it's very interesting because when I asked this to one of the legal luminaries here and they explained what Nishith just said, because it was very unique to India that you need to have the trust set up to do the investments.
Yeah.
Thank you.
Only interesting trust structure, if you put it, is in Liechtenstein and then Luxembourg, called foundations. Foundations are like a trust, but they are actually companies. But the directors of the companies have discretion to distribute the capital and the income of the trust of fund in their. So this is very unusual kind of a company. So it's a mix between company and a trust. So those are other kind of structures. But for the time being, I'll stop here because, as you said, people are more hungry than listening.
Just a minute, I'll open the questions. I think I'm quite confident, conscious of time. I'll just ask two questions. One for Sudhir because particularly he represents also the LPs, which are the investors. What would be the LPs or the investors' wish list for GIFT?
Investors' wish list. I think it's basically the convenience, I'm sure, and definitely investors are also cost conscious. So unless otherwise we maintain the cost, well, I think we would not be able to pass on that benefit to them. And attractive investment opportunities. See, first and foremost is those. Every investor who will be coming to a fund manager is to look for some good investment opportunities. I think that we can provide it in abundance with the kind of flexibility what we have with in GIFT. So in the kind of leverage opportunities or in kind of mix of public listed equities or private equities, unlisted equities, all kind of mix and match those investment opportunities we can create for the investors. So I think. There's the fund management side, that's definitely there is a wide opportunity which is providable, but when we compare with other jurisdictions, there is some requirements can be like in some other jurisdictions you have multiple portfolios could be created with a small deviation changes under the same fund in a very simpler and in a quicker basis. But whereas for us here, every portfolio has to be a separate fund altogether. And here, since this also being an SEZ, the entire setting up a fund takes it to its own process of setting up a real entity in an SEZ and then the trust. So thereby it also increases the cost. Maybe something like that if you could do, because we when we are going globally with the the investment strategy will remain the same, but the investor requirements can be. Someone would like to look at ESG scores built into that. Someone would want Sharia law to be built into it. So it's a investment strategy remains the same, but in the portfolio you might have to do small changes. So what that we would not be able to do in the current structure, whereas I think the master feeder structure and few other structures in other jurisdictions allows that. I think that
no,
really
it's an evolving jurisdiction. All these feedback are very valuable. I think we should capture it. Allow the regulator to do it in phases because they have their own priorities. So not everything can be done in day one. I'm going to wrap this and come to all of you for questions. We'll be surely quick one, Atul. If you are given a wish list on what technology and structural changes can be done to support and develop GIFT in a much more faster pace for a better fund or LP experience, what would be your wish list as a service provider?
I think it's more of a GP or the service providers issues than the regulator, and I think the growth is driven by the institutional investors or the offshore or the domestic investors. With the large pool of domestic money also going into AIF, what would definitely help is the little bit of standardization, both in terms of how the PPM is written or understood. Little bit of standardization into some of the operational related stuff such as the waterfall, because this industry needs to be different than mutual funds, especially with regard to Cat 3 funds. And it is important that with all these novelties in fund structuring, all the different side letters that the fund managers agree with the institutional investors especially, it is only going to add more complexities to how you calculate your now, how much you can become independent in terms of your calculation, what is the manual intervention or the extent of manual intervention into everything that you do. So some sort of standardization in terms of reporting and the way it is structured, PPM language could also help driving the technology changes.
No, thank you, because actually, just to say, the professionals who are engaging in GIFT have all have experience in so many jurisdictions. So it's a great opportunity to bring the best of all that for the current era and make GIFT more and more relevant to the times to come, and for more, as Aditya said, it has been built with a purpose, to serve its purpose. Sorry, we have stretched a little bit. We'll take another 5-7 minutes. You're all here patiently listening. Some questions have been asked. Do you all want to pose some questions to this August panel? Of course, Aditya is also there. He's also can be added to the panel. We can take 5 to 7 minutes. Please go ahead with your.
I just have one relevant question over here. So, basis the discussion that we just had about the VCC, the advantages of VCC, and then the complexity of our own gift city structures, where you have to have an entity set up in the SEZ and then have a trust for every single scheme that you want to launch, and even if the minor variations are there, you still require a different structure. But isn't it possible within our gift structure, if there was a simple line introduced, and maybe Nishith bhai you can opine on this, that at individual share class level, segregation of portfolio will be allowed. If segregation of portfolio is allowed at individual share class level, which is typically, therefore then you will be able to have a scheme at a share class level. So within gift structure itself, while VCC itself was spoken about in the budget, but there was no elaboration on how it would be implemented. But a simple permission of allowing portfolio segregation at a share class level, I think, probably in my view, but you can also opine, it would have effectively created a VC structure within the existing frame.
Simply you're saying it's a multi-class structure.
Multi-class structure.
Which is allowed in the Mauritius actually. The same question I had actually. I also have that.
So, are there any connected questions asked?
This is really
oh my goodness.
This is really connected. Same question.
It's free today.
Mauritius, Dubai, they all allow segregation of portfolio at the share class level. Therefore, you have effectively created a VCC structure or an umbrella structure.
In Mauritius, I need to just simply file a 2-pager document to the FSC and that's closed. Then I can raise the money, I can invest the money, everything is possible. I don't know either.
I think there are some concerns with this structure, even if it were allowed. So of course this goes away from the whole blind pool concept, right? And currently the way the structures work, I mean what we are trying to do is that we are saying that rather than setting up multiple schemes, you do it through a different class of units. I'm talking units because it's a trust structure. Now for every class, let's say there is class A and there is class B. Class A works as a different scheme in that sense. How do you really then measure what is the sponsor contribution for that? You will have to, your accounting will get so complex. Secondly, your investors, and maybe Aarti is the right person to talk about that, I don't think investors will ever be comfortable with such a structure. There is no segregation of assets and liabilities from a book perspective. If there is a, let's say, a tax demand that comes up on the fund, you are not segregating your investors from that particular, one class of unit versus the other class of unit. This structure, even though it's permitted in Mauritius, we as lawyers never advise our clients to do. It's okay to have different classes of units within the same fund to give different rights or interests to investors for the same fund. Let's say, for example, certain excused investors or certain type of investments or certain types of rights that are given, more so for rights like management fee, carry or other rights, special rights that are given. But to form a separate fund through a different class, that's actually, it's more complicated than setting up different schemes. Setting up different schemes is a much easier job to do.
So Parul, one thing, in fact, what you say is right. I had argued first case on protected cell company, Nicholas Applegate. Okay. One advantage was that investors from every cell is different, right? But company is one. So one company could get a benefit of tax study. So there are sometimes issues like that which we might have to consider what are the implications. But this is a larger subject. It's the way in which I look at. choice of the vehicle is a freedom of investor. Okay. And choice of regulator is that so long as it doesn't harm the larger public interest, they should make it free. Okay. So it is between them. There is the freedom to form. That is what is our concept as well. So you can, the way in which I would look at, if I am the regulator, I said, you have freedom to form, okay, so long as you don't take system on right, you are not a bad actor. And then you decide, there are a number of different aspects, as she mentioned, that sponsor commitment, other kind of thing, for which you find a business solution, or you find some kind of a, method to manage the whole thing. But generally I am in favor of laissez-faire and allow people to create number of different kind of entities so long as it's permitted within the law, if there are some tricks around. But most important thing is it today what happens, we are not able to understand different perspective of different people. So we are driving from our own mindset perspective. In the US, even in Delaware, I go there, they have almost every month a meeting with professionals and see what is happening around the world, what new entities are coming up, what can we do here, So series LLC is there. For example, you can create series of different. So there are a number of different forms. One of the things we should do, and I think with IFCA allowing us the testing ground, we can come up with a lot of new kind of entities in India. We should not wait for too long. And it has an overriding power in many ways. And to the extent we can use it the best way, I think we'll create a very competitive regime. Because today we come up with something and then we follow. Like VCC, now we are trying to follow, right? Whether VCC is good or not is for them to decide. We can, as lawyers, tell, okay, this is the consequence, this is the consequence. But there are benefits and there are some, like in case of trust. Trustees have unlimited liability, okay, unless it is properly disclosed and stuff like that. Then you have a company being a trustee, which again is an interesting part of it. So you manage risk in different form. Whole thing would be together with IFCA and all of us can innovate a lot of things, And there, in fact, in Western Samoa, I'm just giving my example, right? They formed a company. Company is formed by only debt owners. You don't know shareholder at one time. Okay, I'm just telling there are different.
So many innovations.
Because in the US there is something called CFC, Control Foreign Corporation, and they to counter that and all that. Western Samoa formed got a form with only debtors owned company, right? No, shareholding is conceptual. So I think we can innovate a lot, and regulator has to, because his job is very tricky. On one side, he is supposed to be the promoter, okay. On the other side, he is a regulator, so he is fixed between the two things. That if somebody takes the new idea on a ride, he would be blamed. We are going to be laughing, right?
That's why it's important to go in a phased manner. So we should give all the ideas to the regulator, but they have the prerogative to pace
and we have to explain that why this is going to be, useful to manage. See, different entities are created to manage different kind of risk, as simple as that. Companies, their limited company partnership, limited partnership and all that thing, these are all the vehicles to manage different types of risk and achieve different kind of objectives. So I think there is a lot that we can do by comparative law studies and, sorry for my
very valid
to extended a conversation.
I'm conscious of time. Maybe I'm going to allow one question.
It's related to the segregation of the network. It is required to be in cash only. It can be debtors, property, investments.
It can be anything.
It can be anything.
Yeah. One last question. Sorry, I know you had you want to make a comment?
No, that's okay. I mean, we can take it offline.
Okay. Yeah, you guys can continue with some food, please.
For you. So we have an inbound fund and we have been raising money globally, but for US and Canada, we understand our underlying is mutual funds. So we understand that this is not a very tax efficient structure for US citizens and Canadian citizens, because the PFIC rules kick in. But if we invest or if we actively manage or directly invest in stocks, so then the normal tax laws come into place. So is there anything which we can expect in future where it will help US investors and Canadian investors to come through the gift structure and take exposure to underlying mutual funds?
No, I think even the mutual funds are treated as a PFIC only, Indian mutual funds. Though that there is no, that the tax which is on a FPI, which is not applicable here. But again, since the mutual fund is a PFIC, even at the Gift City fund also is treated as a PFIC. But only one small difference has been there, that if someone is investing directly in mutual funds where it is taxed on notional gains basis, that would not happen here. It's only on the realized gains basis. So that's the only different. But otherwise, yeah, it would be it's an PFIC vehicle.
I was actually hoping Deputy Sir was saying that there is he's working on the taxation between India and US. So maybe there is some hope if something can happen in future. Which might enable investors to come through gift.
Yeah,
because
so there is actually one more point is there, that is if the fund could register with US as a qualified electing fund, QEF, then the taxation would be better. But I think it's a too laborious process, and it's very difficult to get those registration is what we've been told. So we have to explore that opportunity.
Okay, with that, I'm going to really thank the panelists and Nishith Bhai for the wonderful interaction, and more importantly, Aditya, you want to make any final comments?
Yeah, just 1 minute to clarify two things.
Please.
One of the gentlemen in the audience mentioned something about micro VC, so I thought I would just draw his attention to one of the categories of fund management entity, which is called authorized FME, in which the requirements are quite light touch, and the requirement including the capital, the manpower, everything is quite light touch, and these FMEs are strictly allowed only to do venture capital schemes. So if someone has intention only to do these kind of products in IFSC, which largely intend to invest in startups or new age companies or early stage ventures, then they can explore this category of registration. Under this category of registration, in addition to venture capital schemes, they can also launch angel schemes, in which the minimum capital contribution is as small as $40,000 from each investor. So there are certain avenues which are available for new fund managers who necessarily may not have the net worth and other wherewithal. So that was one. Another was, someone asked about clarification on what constitutes net worth. So there is definition which is given in the regulation. I would suggest to have a look at that, because that definition clearly says that net worth means aggregate value of paid up share capital and reserves created out of profits, securities premium account, etc., etc. So this really does not take into account buildings and other physical assets. So probably that's something which they would want to have a look at. That's it. Thank you.
Thank you. Any final comments, Aditya, for the forum, before you sign off? I know you're not joining us for the drink or food.
So this was helpful for me because I got many suggestions from the panel as well as from the audience, and I'll definitely take this feedback, and we'll have internal discussions on these. And I hope I was able to provide some sort of regulatory perspective to the members there, to the audience there. And these type of forums are typically very helpful in creating awareness about the massive opportunities that is there in IFSC in general, be it ship leasing or aircraft leasing, finance company, so many products which IFSCA has made available to the industry participants here, and particularly the fund management industry, which although has grown at a rapid pace, but there is a huge amount of runway which is available, a lot of opportunities which are there to be explored. So this is a very helpful event. Thank you.
Thank you.